Very good evening to you from Alienated Children First. You didn't hear the first line of my introduction there. And a very special in our webinar series tonight, as we are joined by Judge Marcus, all the way from Israel, Philp Marcus, born and educated in England, moved to Israel in 1978, appointed a judge of Jerusalem Magistrates Court in 1995, served as a judge of the family court there from its opening in 1997 until his retirement in 2012. Judge Marcus is perhaps the quintessential expert in the world at the moment on the area of parental alienation from the most important perspective of all, which is what needs to be done to address it, and indeed the larger picture of what needs to be done to address the family law courts. The international family law courts are in a mess in many countries. It's quite largely accepted, and I think that's fair to say. Certainly in Ireland, we have a Minister for Justice who is very keen to remedy the imperfections of our system. And I'm delighted to welcome Judge Philp Marcus to the program this evening for your insights. Philip, how are you?
We're doing good. It's great to be here in Ireland virtually.
Well, you're not just in Ireland now. We're in England and India and the States and
I saw Poland and other places.
Yeah.
But I was planning to be in Ireland in April 2020. Brian Sullivan invited me to the conference he was putting on, and of course that all got sabotaged. But over the last 3 or 4 years, I've learned a great deal about what's going on in the Irish Republic and in Northern Ireland.
Can I just, I suppose, for those who perhaps are not familiar with the specifics of parental alienation, ask you, from your own personal experience, what is it and what harm does it do?
All right, so the standard definition of parental alienation is a particularly vicious form of psychological child maltreatment, which happens when, for no reason connected with the welfare of the child, one of the parents turns the child against a previously loved parent by using all kinds of techniques that we're not going to go into necessarily this evening. But that causes a breach of the relationship between the child and the parent. And the psychological evidence is that it's exceptionally damaging to the child. Of course, it's exceptionally damaging to the alienated parent and the family. But those are the basic elements, that a child stops having contact with the parent for no reason other than the efforts made by the other parent to sabotage that contact.
And obviously the children and their well-being is paramount in our, not that we would condone any form of abuse, but in this specific case, the children are the ones we want to protect most. Have you seen it actually cause harm? Because there are a number of people who would say, people split up and they have little differences, and there's one of them says your daddy's mean or your mommy's mean, and it's not really all that serious. Would you agree with that?
Well, of course not. I mean, that is the misperception that I know that divorce is relatively new in the Irish Republic. One of the last countries to actually legalize divorce, but parents got separated before that. So it's not connected only to divorce, it's connected to family disharmony. And the effect that it has on the child. I saw children when I was sitting as a judge. I used to interview them in my chambers, obviously with a social worker present. And I was able to see how confused they were and how destroyed they were. And the reasons for that are several. One is that a child who grows up with mom and dad, and they're supposed to love each other, and they are the prototypes, they're the role models for proper couple relationships, and they're the role models for how to resolve disputes amicably, and they're the role models for a loving relationship. A child whose parents separate or divorce loses that, and when it comes him in adult life to make relationships, he doesn't have a good role model to emulate. And if on top of all that, the stability of his home has disappeared, he's now going to be living in two different places, and then because in a situation where one parent has alienated him against the other parent, he no longer has a role model for competent co-parenting. He no longer has a role model for normal parent-child relationships, because often the relationship with the alienating parent with whom he lives is a distorted and pathological relationship. We can go into that more. And of course, he has no relationship whatsoever with the alienated parent. And in fact, he's been taught to hate and despise that alienated parent.
And is that not
that means in addition to all the other damage that's caused by that, the child is liable to grow up believing that half of him is extremely bad, because he's been told by the alienating parent that half of his genes come from an evil person. And that, of course, affects the way the child looks at himself and his relationships in adult life. So there's a whole battery of terrible effects that alienation can have. But I want to point out one other thing, and that is that not every situation where a child is not in contact with a parent is due to alienation by the other parent. There are parents who behave badly. There are parents who are violent. There are parents who are abusive. There are parents who are mentally ill or addicted to drugs. And in that case, it may be appropriate for the child not to have contact with that parent.
But that's not.
However, even in those cases, the child needs help, because the child needs help to get through whatever terrible situation he's been exposed to, which caused the breakdown of contact. So we shouldn't jump to the conclusion that in any situation where a child is not seeing a parent, it's because the other parent is responsible.
So there are legitimate cases where a child shouldn't see another parent, but parental alienation is not that. Parental alienation is where there's no reason the kid shouldn't see the other parent, but is alienated from them by a parent who you've described, I think, as pathologically. What are the effects, though? I mean, does it just mean that the kid kind of doesn't go to as many fun things when they're a kid, or
no?
How many long-lasting effects?
The literature on the topic, Amy Baker, who is a professor of psychology in the United States, has written a number of papers documenting what happens to these children during their childhood and adolescence, but the effects last into adulthood. So, for example, she documents a disproportionate incidence of mental illness, of acting out, of adolescents getting involved in drugs or getting involved in improper sexual relations, getting involved in gangs, with all that involves. Also, a higher level of mental illness lasting into adulthood, personality disorders, suicide. And there's also increasing evidence of physiological disorders. The ACEs study, which was produced by the Kaiser Permanente insurance company in the United States, specified 10 different ways in which a child can be abused or neglected. And where there are 3 or 4 of those, then there's a much higher incidence of mental illness, but also physiological illness, autoimmune problems, heart problems, and so on. So this is not just a kid who's not having a fun time. This is, in fact, the kid may, and this is one of the counterintuitive things that's going on, the child may perceive him or herself to be in a great place. He's being spoiled by the alienating parent and that parent's family. He's being encouraged to do things and gets rewarded if he does something seriously naughty to the other parent. And the child, when the child is interviewed, it may be in the forensic setting, it may be in the social work or psychological setting, the child may not exhibit any overt signs of distress. And that's what makes the issue complicated. And the research and most of the work that's gone into parental alienation has been to do with describing it and then trying to treat it when it's happened. What I'm interested in, as you pointed out, is prevention. What I'm interested in is how we can cut down the incidence of this terrible thing. We'll be speaking, I think, about various areas in which that can be done today. But there's no doubt that the effects are so profound. It's found also that when these people who as children were alienated become adults, they are, because their whole approach to relationships has been messed up, they are more likely to alienate their own children. So we have a cycle of deprivation going down the generations. And that makes prevention even more important, because in that way you can break that spiral downwards.
I suppose
there's another aspect of it that we can talk about, if you like, and that is the economic aspects.
Yeah, I will come to that in a moment,
okay.
Judge Marcus. I suppose, you've painted a fairly bleak picture here. This is quite a serious thing we're talking about. It has lifelong and devastating, I think is the word you used, effects on another human being, and who's the victim of this, the child, of course. And again, we know it hurts the parents, but it's the kids that we're most interested in trying to prevent from becoming alienated in the first place. So the thing that I found interesting about what you said just there, though, was the fact that it's so difficult to identify, and the kid seems to be having a good time and maybe perfectly happy and not even realize they're being alienated. So in your experience as a judge in family law courts, how do you identify a child who is perhaps being alienated?
Well, one of the first of all, you need experts who are experienced and knowledgeable in the field. Not every psychologist and not every social worker has the knowledge and the skills to identify what's going on. But there are a couple of very easy clues. For example, when you ask the child about the alienated parent, a truly alienated child will not find anything nice to say about that parent, and may in fact be talking about things which are simply not within that child's knowledge. I'll give you a couple of examples. A child will come along and with a straight face say, "When I was a baby, my daddy never changed my nappy." Or, "When I was 2 years old, my daddy smacked my mommy." So that child is a very strong indication that child's alienated. A psychologist that I work with, who is an expert in the field, says she was presented by a 12-year-old boy who had nothing nice to say about his father. And she showed him pictures that had been taken 2 years ago of the child with the father at the seaside, obviously having a wonderful time. And the child said, "You photoshopped that picture. It never happened.
Mm.
So that's a strong indicator of this total indiscriminate rejection. Whereas people who are experts in child abuse know that the vast majority of children who were genuinely abused nevertheless want a relationship with the abusive parent. And where they're removed from the home, they want to go back home, and so on. So that's one indicator. Now, of course, I'm not a mental health professional, but my experience has shown me that you need to identify as quickly as possible what's going on in the case. And that means, as we'll discuss, the courts have to adopt a very different approach. And a colleague of mine here says he starts these cases where there's an allegation that a child's been alienated with just two questions. Is little Jeannie seeing mommy, or is little Johnny seeing daddy, or whatever? And if not, why not? And the parent who has to answer that question has to give a pretty good reason. And if, of course, there is substantial evidence supporting an allegation of abuse or violence, then there may be some justification. But if it's just the child, he doesn't want to, and I can't force him, that is a strong indicator of alienation. And the courts have to start the whole ball rolling of getting intervention with the parents, teaching them how to co-parent properly. And in addition, to help the child get through this and break out of it.
And indeed, the courts are really the only recourse that people have to address this issue. And as you pointed out already, they're not always all that educated in the court. So presumably one of the things we might need to do is educate judiciary, or can they rely on professional?
That's absolutely correct, and we can talk about that. But when I'm talking about prevention, I'm talking about a much earlier stage. And we can talk about the courts. I've been observing what's been going on in the Irish Republic. Your Minister of Justice, McEntee, seems to be very interested in reforming family courts and, in fact, relating to parental alienation, but not only with parental alienation. I actually wrote an editorial for the Irish Journal of Family Law a couple of years ago on what family courts need to be done. However, I would like to take this opportunity to talk about two types of prevention, which are before the cases get to court. Because when the case gets to court, it's very often too late. A child who has not had contact with a parent for several months, it's exceptionally difficult to unring that bell. And therefore, we have to be talking about two different stages or types of prevention. There's primary prevention. The medical fraternity will say that, and we know these stitching time saves 9, and an ounce of prevention is worth a pound of cure. These are all trite, but they're all true. So the first stage of primary prevention is alerting the public to the fact that there is such a thing as child psychological abuse by a parent in the form of alienation, and how damaging it is. And that's why the programs that you're putting on, Paul Anderson and Kenn and other people are so important, because they're alerting the public to the fact that it exists and that it's terrible. If you ask the average man in the street, probably only 10 or 20% of them will know there is such a thing. And that's only because they've experienced it or a family member has experienced it. I have to say, although I'm jumping ahead, the courts have an important role in that primary prevention, in the sense that if there are more cases publicized where a parent who has alienated a child is punished because of breach of orders of the court, or is punished because of that alienation. That's a wonderful thing. We can talk about your in-camera rule and what I regard as being a rather inaccurate way of interpreting it later. But that's the primary prevention. But there's a second element to that. And that is that the work I've done and the research I've done shows that many people have children with the wrong partner. And therefore, I'm trying to put together a system whereby when adolescents have relationship classes in high school, they'll be told that physical attraction is very important, but you have to have common goals. You have to have proper communication skills. You have to have proper dispute resolution skills in order to avoid a situation where down the line you're going to have a few kids and you're going to break up simply because simply because the relationship was not based on a firm foundation. So part of the primary prevention is to do with educating youngsters and couples who, before they get married, and couples after they get married, and have a general atmosphere of the idea of having kids is not just it's not a right, it's not a physical function, but there are all kinds of responsibilities attached to that, responsibilities to your partner and responsibilities to the child. Now that, of course, requires a switch in thinking, because we've been bombarded with the idea of rights and of individuality and of self-fulfillment and so on for the last 200 years or so. So that requires a kind of culture shift. I'm working with a group called Two Wishes, where we're trying to effect that. And we're setting up, there is an excellent website which talks about how you change the way we look at relationships and families. So that's the primary prevention. It's getting the word out, but also preventing situations in which alienation is liable to happen.
Okay,
that's the first stage. The second stage is secondary prevention. We can talk about that as well.
Well, let's just talk about where we are now, because in terms of prevention, I think that's absolutely the way forward. But it's something which is going to take a number of years to implement. And as you said, before we can do that, we need to educate people as to what this whole thing is and that it needs to be addressed. And there are some people out there at the moment who don't believe there's any such thing as parental alienation. It simply doesn't exist, which is bizarre, but there you are. Immediately, if we were to address the functioning of the family law courts, and I'll speak specifically about Ireland here because obviously it's the one with which I'm most familiar. The family law courts could intervene today if they were suitably educated, which wouldn't take that long, because it's just a case of a few days of judicial education and a process through which suitably qualified abuse professionals can be identified to do the work and find out whether or not parental alienation is there. But there is a culture in Ireland whereby the judges, and not just in Ireland, in England and in America as well, whereby the judges are very, very reluctant to implement any kind of sanction against a parent who ignores court orders and doesn't allow access and things, because they feel that to put, I've had judges say to me, what do you want me to do? I can't put the mother of the child in jail, can I? But then Bob Geldof famously said in his program on this subject that, in fact, that's exactly what should happen. And that if one man or woman was to be put in jail for 15 minutes, the social stigma would suddenly be attached to it, and people would go, whoa, so this actually does happen now. Oops, because there's a bit of, is that something that would be much quicker to address, would you say?
Well, you have to, of course, train judges to know what goes on in families. That means you have to have a cadre of judges who are interested in dealing with family cases. In my experience, probably 95% of of the judges at the trial level don't want anything to do with family cases because
why is that?
Well, it's because the emotional overlay of dealing with these cases is pretty scary. It may be they may have had or may have at present family issues going on in their lives. It may be that they realize that the stakes are very high in dealing with family cases, because if you get it wrong, then you can ruin the life of a child, and some people don't want to deal with it. However, there are many judges in each country, I think, who are prepared to take this on and to get themselves trained and educated. But
how would we identify those judges?
Just hold on. You also need to educate your lawyers so that they will know to identify a case where there is a possibility of parental alienation, and they'll be able to present it to the court in a way which the court will find acceptable. You also have to have experts who can help the court at each stage to give opinions and to treat these cases. Brian O'Sullivan is in the middle of the first postgraduate course in the world for parental alienation. I'm one of the lecturers on that course, and that's an excellent thing. It's not just enough to educate your judges, but if I may, I want to take a step back from that, and then we will deal with family courts and family judges. And that is, there is a secondary stage to prevention. And that is spotting the signs that a child is affected by the parents' separation and divorce and is turning against one of the parents. And that primary identification is not done in the courts. That's done in schools. It's done by family doctors and pediatricians and social workers and psychologists. A child who is clearly, his behavior is changing, and I'm working with schools and with school counselors. A teacher and a school counselor who have been sufficiently trained will identify a kid who is behaving in a different way to what he did before, and will call in the parents and say, look, little Johnny or little Jeannie, it's clearly there's something going wrong there. And, can I help? Can I refer you to parental counseling? And can we refer the kid to get help? And that is the secondary prevention, because that is early identification and immediate intervention.
So we need a campaign to educate schools as well, because I know
schools are absolutely crucial for that.
Yeah,
because these are professionals who see the kids for 4, 5, 6 hours a day. They are able to observe the child over a period of time. They're able to spot the child whose behavior changes. The results may get worse. They may get better, because the child is so affected by the chaos at home that the school is the only place the child gets any kind of encouragement and support. So some kids do better because of these problems. You get also situations where a child who's been a good kid finally finds himself teaming up with all the naughty kids, disruptive in class, sleepy, all these may point to all kinds of other issues, but they may point to distress arising from the home life of the child. And then if the school counselor or the principal or the deputy principal can call in the parents and say, look, there's something going on here, then one of two things will happen. Either the parents will realize that there is in fact something happening, but it's a problem, and they will do something, or one of them will deny there's a problem. And in that case, where there's denial, that's a strong indicator that there's something going wrong with the parenting being done by that parent, and that's a case which has to get to court straight away by the other parent.
And what about the school's attitude, though? I mean, they're a little bit caught in the middle, and I can kind of understand why schools wouldn't really like to be getting involved in the parenting that goes on of the kid at home, and they would see that as the remit of the parents exclusively, and theirs as being the 9 to 4 p.m. parenting, if you like, for want of a better description.
You're correct. And it's part of the change in attitude that we want to make. There is no doubt that schools are completely on board when it comes to physical abuse or physical neglect by a parent. They're completely on board when there's a situation of sexual abuse or violence. And by putting parental alienation up there as another kind of child abuse, as another kind of child maltreatment, it answers all the elements of the definition of child maltreatment and child abuse, in that it is action that is designed or willingly or otherwise to have a lasting effect on the child's well-being. That is the definition of abuse. And therefore, school principals, teachers need to be convinced that this is part of their remit in the same way as they are required in many countries to report suspicion of physical abuse or sexual abuse. So psychological abuse, in fact, it may be more devastating than physical abuse. If you know, there's I don't want to minimize the effects of physical abuse, but it's over and it's done with. Whereas the child who is alienated from a parent carries that psychological damage throughout his or her life. And therefore, again, this is part of the publicity campaign that needs to go on. It needs to go on in colleges, in teacher training colleges, in universities, for law students and psychology students and social work students, and all those who are training for professions which are bringing them into contact with children and their parents, with a view to enabling them to identify the situations and offer help before the case becomes so deep that the child has in fact cut off all contact with the parent.
But it's not too late even then, is it? I mean, there's still some hope that
well, that's the whole point. The whole point is trying to head off the evil effects. Yeah. When the child has in fact cut off contact, then, as I say, there are programs for restoring contact. There are unfortunately, some charlatans out there who think they can do it or say they can do it and really can't. There are some who do a lot of damage in the process. So you need here a team of properly trained and experienced people to do that work.
One of the issues that they have, though, because I've spoken to a few of them, is that they believe that what is required initially is a severing of the relationship with the alienating parent and exclusive access to the alienated parent for a period of perhaps 3 months, during which the child can reestablish normal relations with the parent with whom the relationship has been severed. and then reintroduce the alienating parent who in the interim has hopefully had some therapy or whatever it might take to remedy themselves. And judges, I don't know if you found this, but certainly in Ireland, if you go into a judge and you say, I would like, an order, a transfer, residential transfer order of my 3 children from my ex-husband or my ex-wife for a period of 3 months, so that we can redevelop it, they simply will say, well, the child is so happy at the moment, we don't want to rock the boat.
Okay, so you've pointed out a type of therapy, which there are programs like this. Some of them work extremely well, but they're extremely limited in scope. I think in the whole world, we may have 500 or 1,000 kids who've been through this. That's a very small sample to draw conclusions from. And there is a risk that if you do, in fact, remove a child from what the child perceives as a loving relationship, then it may well be that the parent doing the alienating is an okay parent in all respects, except that the alienation. You may, in fact, achieve some kind of contact with the other parent, but you've also done some damage to the child in the process. There's also a situation where a child realizes that he or she has been manipulated and alienated, and because of that will not want to have contact with the previously alienating parent. So the child gains one parent and loses the other parent. So these are desperately difficult decisions that a court has to make. And that's yet another reason why we should be concentrating more resources on prevention, on primary prevention, and the kind of secondary prevention, the early identification and immediate intervention, in order that cases should not deteriorate to the case where you have to take these very radical actions. You mentioned also the issue of sanctions, judges are reluctant to use the powers they have. Most countries have something like contempt of court, whereby a party to a court case who is ordered to do something and fails to do so can have sanctions imposed, including imprisonment or a fine. Well, my experience is that sometimes the threat is good enough. I can tell you about a judge in Canada who I met who said that he has a couple and they come to him on a Thursday and he says to the mother, look, it's Johnny's time to be with daddy on Sunday, and if he's not with daddy on Sunday, you come to my courtroom at 8:30 on Monday and bring a toothbrush, because I'm sending you to prison. And that threat is good enough to make the change. I used that in a case I dealt with. I had a wonderful experience a few years ago. I was at a wedding and a gentleman came up to me and said, Judge Marcus, and I said, yes. He said, do you remember me? And I dealt with thousands, maybe tens of thousands of dads over 17 years. And he gave me his name, and I sort of remembered what he says. I'm still seeing my kid. Now, this is a couple. She'd been married before. And while the child was still an infant, she wanted the father not to have contact and made all kinds of allegations which were proven to be without any foundation. But she manipulated the social services, and she spun out the mediation and so on. It became clear to me that she had a personality disorder until the stage where I told her that if little Johnny, obviously a made-up name, is not with daddy this weekend, I'm sending you to prison for 3 days. And for those 3 days, little Johnny's going to be with daddy anyway. So which would you prefer? And 8 years later, this guy came up to me and said, that was enough. Now, in Israel, the courts have developed a whole string of sanctions before you start threatening with prison. For example, you can impose court costs. You can impose, you can reduce child support payments. Now, of course, if you're dealing with a poor family, those financial things are going to immediately impinge on the child. But we can also suspend a passport so the guy cannot travel abroad, or we can stop him using a bank account or a credit card. And these things really hurt and concentrate the mind wonderfully. So that, there is another unfortunate effect where courts are too reluctant to enforce their judgments. And that is that the parent who is not complying with the court order thinks that they got off scot-free. But the child also learns to disrespect the court system. That's why the implement is called contempt of court, because it brings the court into disrepute. And I have heard of cases in England and in other places where judges, after 2 years and trials and expert reports, and come to the absolutely clear conclusion that the child is alienated and orders that contact will happen. But then when the contact doesn't happen, the court does not do anything about enforcing the orders. That is, in my humble opinion, a disgrace. I saw some figures that in a very tiny proportion of cases where the lawyer for the parent wants enforcement proceedings, a very tiny proportion is anything actually done. Now, that is outrageous. That is really dropping the ball. And judges and lawyers, but particularly judges, need to be trained that these are matters almost of life and death because of the psychological effects that we spoke about. And bearing that in mind, and also the way in which the court is perceived if it doesn't enforce its orders, that's very dangerous to the whole society. We have an additional issue here which I referred to briefly, and that is, if it appears in the newspaper that a judge in the court in Ireland sent a parent to prison without identifying who the person is for non-compliance with the court order, that, I think, will have a chilling effect on anybody who thinks that they can get away with it. It only takes a few people to be pilloried for non-compliance for the picture to change. And therefore, part of the training for a judge is, of course, to understand how serious things are, but also to utilize the tools that the judges which are available to the judge to enforce contact.
Okay, I've about 400 questions coming in here. Can you please ask Judge Marcus this? Can you please ask, which we will have a question and answer at the end of the session, but so that that's not 12 o'clock tonight or 1 o'clock in the morning. I'm very keen just to hear from you. Firstly, I suppose, on how do we remedy the court system in Ireland, and secondly, then how do we, in the longer term, look at prevention? And I'd be very interested in hearing from you about specific actions that we might take. And just to color the background for you a little in Ireland, I think it's fair to say that we have a culture in Ireland of, you know, the woman's place is in the home. I suppose England grew up with the same thing, and we possibly inherited it from them. And the man's job is to go out and provide for the woman. You know, I have heard fathers tell me of high court judges who have told them when they've said, look, I'd like to stay home and take care of the kids like I always did before the marriage broke up. But now my wife continues to work anyway, and the kids are with nannies or they're in a creche. Why can't I take care of the children? And the judge would say, so what you're suggesting is that you stay home all day with the kids doing nothing and put your poor wife out to work. And that kind of mentality is something with which children grew up, and then those children became barristers and solicitors and eventually judges. And it's going to be very difficult to decolor the upbringing that those children had. And when we go to introduce the need for judges to be educated, there may be some resistance.
That's quite possible. And that's why I said that not every judge is suitable to deal with family cases. And that's at all levels. And that's why you have to find in each country has to find judges who are prepared to take on this kind of work and are prepared to educate themselves and prepared to see how life actually works in all kinds of different family settings. What you say about the woman's place in the home, that's changed radically in the last 20 or 30 years. To say that bringing up children at home is not work, well, that's nonsense. Of course, the roles need to change, and they can change. They have changed, and that again goes to what I'm talking about when I talk about parental responsibilities. That the parents have a responsibility in every situation to split up between them the different roles of child bringing and child education and so on. But when they split up, those responsibilities do not change. They still have to make arrangements that all the needs of the child should be properly supplied, and therefore you need to deal with it on a case-by-case basis. What I said when I looked at the situation in Ireland, I saw the following thing: that there are very few judges who have specialist training and specialist knowledge of the field. What happened in Israel, and let me just tell you about the history of the family courts in Israel. In the early 1980s, they came to the conclusion that there was a need for specialist family courts. They then set up a commission which reported in 1986 recommending specialist family courts. It took until 1995 for the legislation to go through. So, but also in Ireland, you have to start somewhere. But there are things that can be done without primary legislation. For example, if you can in each area have one or two judges who are prepared to take the family cases on, who are prepared to educate themselves or go to courses, and who are prepared to collaborate with people of other professions in all these cases. And then the court system will divert cases like this involving children to those specific judges. Then you are producing a professional cadre of people who understand these issues, understand how difficult they are and how much they need to be handled. You can also do a great deal simply by structuring the court day differently. So that instead of the court day involving a judge hearing criminal cases and civil cases and family cases and traffic cases, to have all the family cases either in a separate courtroom or to devote one day a week so that all the family cases can be dealt with together. And what that means is that you'll have the same lawyers the experts showing up on a specific day. You'll have the social workers available to handle the cases. In Israel, there is a social work unit, which is an integral part of each family court. So that without changing the law, you can professionalize and specialize the way in which family cases involving children are handled. As you say, there will be resistance. I was a judge. Judges are notoriously conservative in the sense that they are resistant to change, but there are always judges who can be convinced that things need to be done differently. There are other things that can be done. For example, having lawyers who are prepared to act as guardians ad litem for children, who are prepared to study and learn and get expertise in the field and represent the needs of the child, where the father and his lawyers are representing what they perceive as being the needs of the father, and the mother and her lawyers are representing what they perceive to be the needs of the mother.
So you're talking about three separate words.
The judge is in the middle. There's a battlefield going on. But if you can appoint a guardian ad litem who can be a lawyer and knows all the tricks of lawyering, or a social worker or psychologist who has a lawyer in the background, then somebody is actually going to be representing the best interests of the child before the court. My experience is that a good guardian ad litem can in fact mediate between the parents simply by presenting what's liable to happen to the child if the case is completely litigated, and if it has been completely, the best way to deal with the matter would be through mediation or by some other alternative dispute resolution.
But are there not practical implications for that, in that we are now taking a system which currently has two lawyers adversarially attacking each other in a courtroom representing either of the marital parties, to the introduction of a third party independently representing the children?
I want to tell you from my own personal history, because when I was a young lawyer, I was approached by a professional colleague from New Zealand to represent a lady who had married an Israeli guy, and they went back to New Zealand, and the father brought the children back to Israel without the mother's permission. And in the papers, I saw that the court had appointed a guardian ad litem for the children. And I thought, this is a great idea. I was then a member of a council for the rights of the child, and I brought this idea up. And there was a social worker there who was the head of one of the child protection organizations, and there were lawyers, and they said, what? Another lawyer? But the mother knows what's right for the child, and the father knows what's right for the child, and the social workers know what's right for the child, and the judge knows what's right for the child. Anyway, I persuaded him, and we set up a pilot scheme, and we had a few lawyers who prepared to represent children. They had a social worker working with them. And now the legal aid in Israel will provide a lawyer free of charge in any case where a judge refers a child. And these go through a very, very serious training system. And they know to represent the interests of the child. In an older child, they will also tell the court what the child wants, but will also have experience in creating a relationship with the child to show that sometimes what the child wants is not what the child needs. So having it's not a third wheel, but you've actually referred to another issue, and that is the adversarial nature of family proceedings. One of the conclusions I arrived at, and in fact the Israeli family court system arrived at is that the adversarial system is inappropriate in most cases involving children, because this is not an issue of did he kill her or did somebody else kill her? This isn't an issue of were the tomatoes that were delivered rotten or were they not rotten? These are not parties who came together because somebody drove his car into the other one, and when the case is finished, they will never see each other again. These families, separated, divorced or not, they're going to carry on being responsible for their children into the future. And therefore, I used to tell people who came before me in my court, the last thing you want is for me to make a judgment saying that this person is better than the other person, or this is a custodial parent and this is not the custodial parent. What you need are the tools to carry on bringing up your children separately, but together in the sense of co-parenting. So that is also, I am under no delusions. This is a paradigm shift for many lawyers who are brought up to win. These cases, the only people who lose, or the people who lose most, are the kids. So that what I'm talking about in court reform, as well as the technical reforms that can be made, and I understand there's going to be proposals coming up very shortly in Ireland as to set up a specialist family court. But it doesn't begin and end with just having specialist judges. There is a need for a paradigm shift in the way in which we think about handling these cases. There is, in fact, a body now called therapeutic jurisprudence. It started off in criminal courts dealing with drugs and so on. Then the idea was to involve not only the prosecution and the defense, but also the family and the people around the alleged offender, and giving incentives for that person who may be addicted to drugs to get off the drugs, and give a lot of support by the court to reward good behavior, getting support from the community to get the guy into a job, and getting the children and the wife the support they need. And they've been extremely successful by looking beyond the black-white binary, guilty, not guilty, or the custodial and non-custodial parent. If you get beyond that binary, you realize that there are other interests involved. Then you have a better chance of making life better for the children and, of course, for their parents.
So you've touched on the issue there, which I was going to come to, of a dedicated family court, which, as you correctly pointed out, our Minister for Justice is currently looking at here. Is that a good idea?
Excellent. I think it's essential. There's a perception that family cases are just the same as any other civil case. It's simply not true. It's a different thing. It's a different system.
There's often no criminals.
Say again?
There's often no criminals. There's often no guilty party.
Exactly. And I wanted to point out one other thing. I mentioned this. This court needs to publicize its decisions. You anonymize them.
We do.
You don't say Mr. Bloggs and Mrs. Bloggs and all the little Bloggses. You call them A, B, and C, or the father and the mother. You don't. There is, in fact, a seminar going on today and tomorrow. We have annual seminars for all the family court judges in Israel. And they're going to be talking about how efficiently to anonymize a judgment, because then the lawyers and the public will know what happens in these cases without running the risk of identifying who the parties are and their children are.
which is a big problem in Ireland because
I know,
you can't get any
because of your sub judice rule and
the in-camera rule, yeah.
your in-camera rule, it has not been part of the thing to publicize what goes on in the family courts.
No.
That leads to all kinds of allegations, which are usually completely untrue, about how the family courts deal with the cases. But I think it was Justice Brandeis who said that sunlight is the best disinfectant. If these cases can be made not completely transparent, but they can be publicized, then it increases the regard with which people hold the family courts, because they're seen to be doing sensible stuff.
Again,
and
though,
as I pointed out, as far as I know, there's only one reported case of a judge in Ireland, was it a year and a half ago, actually calling out a parent for parental alienation.
Yeah, April last year in Limerick, Ennis Court.
Right. But if the newspapers get hold of more cases like this, it doesn't even the report in the newspapers doesn't even have to say where it was. It doesn't even have to say which court it was.
The big problem in Ireland, Judge Marcus, our former Minister for Justice, Alan Shatter, did introduce a raft of changes in 2015, whereby journalists for the first time were entitled to enter the courtroom. However, there are so many exceptions to the rule that a judge might.
I am not saying that the journalists should be allowed into the courtroom. In Israel, all family cases are held in camera. Nobody outside the family and their lawyers are allowed to be present. But the decisions of the court are publicized, and the decisions are given with reasons, and that the judge spells out all the issues and all the events which led him to make the decision he made, and in that way the whole story is presented to lawyers and to the public, so that that you build up a precedent, you build up a list of case law, and then it also helps in the sense that lawyers can advise their clients what's likely to happen in a particular case. Or, as I say, an alienating parent who sees that somebody went to prison or lost his driving license because of non-compliance with a court order will think twice and three times before doing it. So that your in-camera rule, I think, needs attention. And I think that you can move ahead in that way. Again, it may not require primary legislation. It may just need a directive from the president of the court or whoever the appropriate official is.
And indeed, our Minister for Justice and her department has pointed out that we don't actually need any new legislation, because we already have legislation against children being abused, and we just need to identify that parental alienation is abuse, and therefore the rules can apply. Coercive control is another one that might be brought into play. We have coercive control legislation already since 2019, but again, it needs to be better understood. So we've identified, therefore, that we need a paradigm shift in the judiciary. We need an education process for the judiciary and all the professionals associated therewith. We need the schools to be educated. We need dedicated family law courts. We need a reform of the in-camera rule to allow publication such that case precedents can be known to the lawyers so that they can help their clients better understand what's likely to happen. Now we have the picture of what needs to be done. How would you suggest we specifically go about the implementation of steps which will bring us to that ultimate conclusion?
So in order to answer that question, I would have to know a great deal more about the system in Ireland, and about the relationships between the different professions, about the willingness to change, and so on. One of the things I do in the last few years is I offer formal consultations to organizations and governments. And that would involve, visiting. It would involve dealing with all the stakeholders, all the people who are involved, and offering, on the basis of my experience in Israel and reviewing what's going on in other places, what's the correct way to go about it. And just give an example that. And in fact, the editorial I wrote in the Irish Journal of Family Law spoke about that. There are some things you need legislation, some things you don't need legislation for, but that's very much dependent on having the appropriate people in the appropriate positions to move this ahead. The constellation in Israel in 1995, when the family courts law was being debated, was such that we had a Minister of Justice who was in fact a family law expert. We had a social services minister who was interested in the reforms. But even now, it's only in the last year that our education ministry has been willing to take on board changing the ways in which teachers and schools handle cases involving psychological abuse of children. All of these things are very much local, and while I can and I've given fairly general indicators of the way to go. It's for each country to find its own way, to find its own order in which to do things, and that's why the organization that you're involved in has been doing the publicity, has been getting the thing before the public, has been approaching members of county councils and so on.
And we continue
that's
to
a
do
good
so,
springboard.
It's a step in the right direction, but it's still a long way from seeing any tangible results. I have a copy in front of me of today's Irish Legal News, and the headline is "Judicial Training in Ireland Held Back by lack of time and resources." Yeah,
that is a classical penny wise, pound foolish way of doing things, because and I probably should have mentioned this earlier. If family cases are dealt with more efficiently and quicker, you need less manpower, you need less court administration, you need fewer judge hours, because if you can get these cases at the very outset, then you don't need the full-scale trial. You can deal with these issues by giving interim orders and enforcing them. I can tell you from my experience that the more time that a judge invests at the early stages of a case in judicial management, in making sure that orders are properly drawn up and calling the parties and their lawyers back every 2 or 3 weeks to make sure the orders are being enforced, that will avoid a trial, because down the line there won't be any necessity to try the case. The parties will come to the conclusion that they need to settle, or they need to organize things in a proper way.
And indeed, another thing that hasn't really been examined is, the societal economic cost to children who grow up dysfunctional as a result of improper court management of their parents' separation, etc. Have you looked into that at all?
Oh, yes. I have a research proposal which I produced with a professor of economics and a professor of epidemiology from the health services. We're trying to get funding for a partner for that research. So if anyone's listening in, would be interested in taking part in that.
What would be the outcome of the research?
We've identified, speaking specifically about parental alienation, the areas in which governments have to shell out huge amounts of money to try to put right what could have been prevented in the first place. So, for example, supposing you have a child who is alienated and becomes mentally ill. So a mentally ill person is going to need support and investment from the health services, may need a psychiatrist, may need hospitalization, but also because of the mental illness, may get involved in committing criminal offenses. Then you have the police involved and the prosecutors involved and judges. And if you have juries, then juries and the prison service. And even in the social services or in education, it's been shown that children of divorce, very often their education is affected, and thereby their achievements are less, and thereby they get poorly paid jobs, or they have long periods of unemployment. And if they're unemployed, they're not earning money, they're on the dole. And if they are being employed in low-paying jobs, they're not paying taxes because they're below the tax threshold. So that if you can invest money in prevention, primary prevention, and the secondary kind of prevention I'm talking about, then there's going to be a huge saving to the exchequer. We are going to look at the thing, if we get appropriate funding and support in Israel, but it's the kind of thing that we could do in partnership with other countries.
But wouldn't that make everybody's job so much easier if you could go to the government and to the Minister for Justice and say, well, look, this is costing your society so many billions per year, according to this professor of economics, and here's a breakdown as to why. We'd like you to invest 10% of that to prevent it from happening.
Absolutely.
Wouldn't that be an easy sell?
One would think so. But unfortunately, there are all kinds of things going on. That is that many civil servants don't like the idea that their budgets will be cut. And so there'll be maybe some resistance for there. And because the subject itself is so horrid, the idea that children are being abused and neglected in this psychological way, there may be a reluctance to get into it.
Yeah.
Add to that as we spoke about, the inherent conservatism of certain areas of life. And the fact is, we've been trying to get funding for this research for far too long. We still haven't managed to do it. But there are prevention programs going on in Israel. Some of them have been quite successful. I'll just give you one tiny example. A year ago, the president of our Supreme Court issued a directive that where there's any case brought before the family court, where there's an allegation of abuse of any kind, physical, sexual, or psychological, the first hearing has to take place within 14 days of filing, and the judge at that hearing is able to give directions about investigations, about producing social inquiry reports, even therapy and contact. And the judge will usually give orders like that and will have the parties back before him in 3 weeks for reports as to what's been done and what's been achieved, and will appoint a lawyer for the child, so that we strongly believe that this directive has only been in existence for a year, and they extended it for another half a year. We're waiting to see the results.
But that's the kind of very, very sensible specific that could be implemented here. We have the same. We have problems here where there's one person on our books who I know of who works in a school with 130 children for whom this person is responsible every day, but there's an allegation about this person from somebody else to the effect that they should not be around children. And as a result of that, this person is not allowed to see their own children, but they're allowed to work perfectly well taking care of 130 other people's children.
All right. So it needs somebody with common sense to see the absurdity there.
It is bizarre,
and to present it in a way which a judge will see the absurdity and will be able to change things around.
Presuming the judges had that paradigm shift required in the first place.
Okay, I've called it a paradigm shift, but I'm not sure it's that radical. It's simply seeing what's really actually going on. And there's plenty of material there, and there are plenty of qualified people to teach these courses. What I did in Malta was I got, I presented a program, got half a dozen of my colleagues, psychologists and professors of education, and social workers and mediators. And they all took part in this course. I think Brian O'Sullivan's course also has the same sort of multidisciplinary aspect. One of the other things I'm strongly advocating for is that people in different professions should work together, and each should learn about the other professions, the ways of doing things. The social workers need to know what the judge is able to do, and the judge needs to know how the social workers deal with cases, and the same with psychologists and others. So that's also, in some places, the idea of working together with members of other professions is we don't do that. They do their job and they do their job. But it's been well said that a specialist is somebody who knows more and more about less and less until they know absolutely everything about nothing. There is a danger in specialization if it excludes the possibility of learning from other people, and therefore there need to be joint training sessions for all of those who are involved, so they're all on the same kind of page.
I'm going to go to some of the questions that have come in.
No problem.
Simply never get through them, Philip. And I'll just pick them at random. Why does the illness of parental alienation, and do you consider it that, I suppose, is an integral question there, still exist, and where it is beyond obvious how devastating it is?
Well, it's obvious to people who are involved in the field. The problem is that not enough people are aware of what's going on. Calling it an illness is a subject of some dispute. There are those who say that parental alienation is a psychiatric or a psychological condition of children. I am not convinced. I think it needs to be described in terms of behaviors, in terms of what's actually going on in this specific family, and what the effects are on this specific child. And I'm not sure that the medical analogy is really appropriate, or to put it differently, I'm not sure that the medicalizing it is really helpful.
It's a tricky one because a lot of psychologists to whom I've spoken would say, nobody in their right mind would abuse a child the way a parent in this case is abusing their own child. So there has to be a screw loose there somewhere.
Right. Okay. But we have to be very careful, because I mean, it's true in my experience, but I'm just a lawyer and a judge, that many alienating parents have personality disorders. There's the borderline personality disorder, the antisocial personality disorder. There's the narcissistic personality disorder. Now, once you start describing cases in those terms, then you're going to open the field for lawyers to say, oh, well, a narcissistic personality has criteria A, B, C, D, and E, and this guy only has A, B, and C, and therefore he's not a narcissistic personality. Well, does that debate help the child? Probably not. It may help the judge to manage the case, because if he knows or he feels that because one of the parties may have a personality disorder, certain behavioral things, both within the family but also in the court, may be predicted, then in that case, it'll help him to manage the case. But we need to be talking about what is happening to this child. We also need to be looking to the future as to how do we remedy the situation which has arisen. And spending weeks in court proving what happened in the past may be fairly useful. But if that effort can be put into providing solutions in the present and for the future, that's a much better and more efficient use of resources.
The joy of international broadcasting over the internet is such that we have a caller from a viewer from Holland who says that in the Netherlands, we think that waiting until the case comes to court is too late. If one of the parents take the children with her or him and preventing access, I'm interpreting here, the other parent to have contact or interrupting the parent from having contact, we think that the police should intervene, and that seems to be the case in the Netherlands, which would be great, except that certainly in Ireland they will simply tell you it's a civil matter and therefore we will not get involved.
All right. So there are a number of different issues that this question brings up. One is whether parental alienation is going to be classified as a criminal offence, such that anyone doing it can be picked up by the police and prosecuted. Now,
like in Mexico, where it comes with a 10-year jail sentence.
Yeah, but I have not yet had any information from Mexico that anybody's ever been prosecuted for it. There are all kinds of issues there. I've written a paper which I can make available if anyone's interested about all the different legal and judicial ways of dealing with this. And I came to the conclusion, on the basis of discussions with people in Romania and Germany, that providing criminal sanction will not help the child. However, where there is a contempt of court and there's an arrest warrant, then the police have to do that. They have to deal with it because, they have to bring the guy to jail. So I'm not familiar with the situation in the Netherlands, but I know that there are some countries in Europe where you're not allowed to mention the words parental alienation because of what you said, that, the people who say that it doesn't exist or whatever. So you have to frame things differently.
Another one here.
It is indeed a civil matter, but the court has powers in most places to enforce the orders.
And indeed, if the orders are not adhered to, they can always be forced by way of the person being found in contempt of court.
That's exactly what I have in mind.
Yeah.
But also, as I say, there can be a rising scale of penalties. If, for example, on the first breach, it's €200, The second breach, it's 400 euros. The third breach, it's 1,000 euros. Then there are ways of tackling the issue of sanctions. Each country will, of course, build its own system.
In fairness, Alan Shatter, whom I mentioned earlier, did try to introduce that in 2015 here, but there does appear to be a culture which requires the paradigm shift of which you spoke, wherein there is grave reluctance to introduce any kind of punitive.
Things are different in 2022 to what they were in 2015 in many areas.
Okay,
there's increasing awareness and there's increasing understanding that certain things which were unacceptable but were not called out are now more frowned on, and of course we've spoken about conservatism in the small c sense, right? The resistance to change, but the people change and attitudes change. And there are plenty of examples of that.
Very slow form of paradigm shifts, though. Another one has come in, which you've kind of partially answered already. I'm an educationalist, and I'm horrified by the inclusion of "quote unquote" teacher evidence used in parental alienation cases. What are your views on the need for teacher training to understand PA? And I suppose what they're really asking is, what kind of training should a teacher have so that they're qualified to do that? Right.
Okay. So this brings up another very important point, and I think I saw in the chat one or two references to this. The issue of schools points in several different directions. I mentioned the need to educate youngsters about relationships and about parental responsibilities. I've indicated the school as a possible tripwire to warn, but I had before me cases where the school or one of the teachers had been rounded up and had been recruited by the abusive parent, the alienating parent, or to agree that a child had been abused on the basis of very little evidence. And this was a very convincing lady who convinced the kindergarten teacher and the supervisor that the father of the child had committed some terrible offense. They came along and gave evidence. And after two questions from me, did you actually see any signs of this? Well, no. And so how do you know? Well, the mother told me. So the teacher training needs to include all of these elements. It needs to, one of the things that a school can pick up, I spoke only about the behavior of the child, but there is parental behavior, which, if properly observed, can indicate a tendency or the beginnings of alienation. For example, supposing the parent shows up in school with the partner and registers the partner rather than the child's other parent as the person to be contacted if the child is, if there's any problem with the child or whatever. Mm-hmm. I've seen it happen. I've seen cases in which the parent comes along and says, there's a banning order against the other parent from getting anywhere near the school. So the school authorities need to say, show me the document, show me the order, so that they'll be convinced that this is not just an attempt at alienation. And the teachers also need to be educated as to hold the proper balance between the parents, not to jump to conclusions on the basis
of particularly in a school setting, whereas the the school authorities may well have the power to ask for copies of court order. Much of the dynamic occurs in the schoolyard whilst the parents are waiting for and then they chat and this happens and did you hear about this, and you know,
so you can't stop people talking, but the entire school staff need to be on board with this. I heard a lecture by the principal of a school in the United States saying that one of the most important sources of information about the behavior of the children and how the children are is from the crossing guard, the guy who takes the kids off the school bus, because he's a nice old gentleman and he's on first name terms with all the kids, and he can see the little Johnny or little Janie are behaving differently, or they're depressed, or they're not clean, or whatever. The second thing is that at the end of school time, so supposing it's Mr. Bloggs' turn to pick up the kid, but Mrs. Bloggs shows up to pick up the kid and starts screaming at Mr. Bloggs that he didn't pay maintenance this month, or that his girlfriend is a so-and-so, and etc. And that this is the kind of behavior that the school should be observing and should be calling in the parents and saying, look, this is not acceptable behavior. We think that you should be getting advice, counseling. The child is obviously affected by it. The child's friends hear all this, and the child's friends' parents hear this. So that's another way in which the school can observe parental behaviors and get help for the parents and thereby for the child.
It'll be interesting to see whether we can condense that into a 2 or 3 page pamphlet which will sufficiently educate the children to.
I'm working with
schools, I think, for not the children.
One of the things I'm working on, the Parental Alienation Study Group has a subcommittee on prevention. And I'm working with that committee. And one of the members has actually produced a pamphlet for educators. We're going to be working on that. I think we have our next meeting in about a month's time, and we're going to be working about finalizing that and then issuing it. But there has to be follow-up. It's not just enough to distribute a flyer. You have to have opportunity for teachers and school principals and crossing guards and the lady in the canteen to have some kind of training session, some kind of educational face-to-face thing and appropriate materials. That's the next thing we're going to be working on.
Well, I would welcome a copy of that first to put up on our website.
No problem.
When it's ready.
We will.
I'm going to finish on last question. We've actually gone over time now, but there's one here that I'm going to put to Philp Marcus, the lawyer, rather than Philp Marcus, the judge, which is, does Judge Marcus think that perhaps the Irish judiciary is reluctant to elevate parental alienation to the level of physical or sexual abuse because of the prospect of a constitutional challenge that the family is the primary social unit of society, which is something which is in the Irish Constitution, and I imagine others to lesser extents, but because of our religious backgrounds, that's something that's written into our Constitution here. What would you say to that?
Nothing in that very laudable and true statement in the Constitution should get in the way of protecting children from being abused or neglected. And I'm absolutely convinced that the constitutional judges will say, I mean, you don't need to go to the Irish Constitution. The Article 8 of the European Convention on Human Rights talks about the right to family life. And there have been many, many, many cases before the European Court of Human Rights where on the basis of Article 8 and the European Court of Human Rights has called out governments which do not properly handle cases involving allegations of parental alienation.
And is it the case that the European Court of Human Rights also, in some of its legislation, says that a child has the right to both parents?
Absolutely. That is implicit in that. That's one of the ways in which Article 8 of the Convention is interpreted by the European Court of Human Rights. And there have been cases against many, many, many different countries. I cannot recall if there's been cases against Ireland, but I know there have been cases against Great Britain and Russia and Ukraine and Malta and a whole bunch of countries.
Well, there haven't been any cases against Ireland that I'm aware of as yet, but perhaps as a result of this evening's webinar, there may be soon. And on that note, unfortunately, we have hundreds of other questions here. I'm going to talk to you off air and with Paul about the chance of a follow-up, because we have such a reaction to this, Judge Marcus, as indeed we knew we would. There's thousands of questions.
If anyone wants to be into contact with me, or if anyone wants to have copies of the articles I've written, you'll be very welcome to be in touch with me. I'm sure that Paul and Ken will give my email address to anyone who's interested.
Just tell us what it is there now while it's fresh in their mind.
The email address is Philp Marcus Jurist, all one word, at gmail.com.
And that's jurist with a J.
Yeah, that's Philp Marcus Jurist, Philip with one L, Marcus with a C, and Jurist with a J. And my website is philip-marcus.com. I'm also on LinkedIn, if anyone's interested.
Well, Philp Marcus, jurist, it's been an absolute pleasure. And thank you so much for your time this evening. We look forward to the next one.
Thank you for inviting me. And I hope we've helped a few kids this evening.
Fingers crossed. Many thanks for your input.
Be well.
Bye-bye.
My baby ain't my baby, my baby ain't my baby, my baby ain't my baby anymore. My baby and my baby, my baby and my baby, my baby ain't my baby